Hey guys, there are two reasons why I want you to take a look at this decision that came out just a couple of days ago. This is a Fair Debt Collection Practices Act case. The first reason is it emphasizes why we always talk about if you're going to go into litigation with a debt collector, with a credit bureau about your credit reports, you have to have your real credit reports, not Credit Karma, not Smart Credit, not Identity IQ, your real credit reports from the bureaus directly. The second thing I want you to see is why we always talk about this section 1692E8. That's a failure for a debt collector to mark your account as disputed. Why we always say you have to dispute it, and then if it is updated, it must be marked as disputed. Why do we say if updated? So those are the two lessons that I want you to see from this case that came out on June 24th. So let's take a look at this. There was summary judgment filed by the defendant. That's where the defendant, debt collection firm or debt collector is saying, hey judge, no reason to have a trial, just summarily enter judgment. Let's get rid of this case. And the judge agreed. So what happened is that this debt collector reported to the national credit bureaus, that would be Equifax, Experian, TransUnion, about certain debts with this Tennessee Orthopedic Alliance, TOA. And so November 2019, there's a letter sent to the debt collector saying that the consumer disputed those accounts, and there's no question that the debt collector received that letter. But the debt collector did not report to Equifax that the debts were disputed. Instead, what they did is they told the bureaus to remove all of the information, okay, not just for this client, but for this consumer, but for other consumers. And so remove all of the accounts from their services. And so let's look at a couple of these little footnotes here. And this will be on that first point about Credit Karma. And we'll see this again. The record reflects plaintiff obtained a Credit Karma summary of her Equifax credit report. This summary was not created by Equifax. It works with Equifax and TransUnion to give them access. Okay, so Credit Karma is fine. There's nothing wrong with having it. It's really good, actually, just to give you an update, an alert. But you always, always, always want to go directly to the source of the data, which is either go to Equifax.com, Experian.com, TransUnion.com, or the easier way is you go through annual credit report, which then connects you directly with each bureau. And you can do that for free once a week for each bureau. These are your real credit reports. And we'll see this is a big problem when people bring suits based on not having the actual real reports. Okay, so there's also this sort of troubling footnote here. Plaintiff testified in her deposition she did not actually dispute the amounts owed. She's simply unable to pay. She's working with a credit repair company. And so that didn't help. It's not the reason she lost, but it certainly didn't help. So then we have this Penny Bays, who's worked for this debt collector for many years, does not recall there ever having been an issue raised where one of the bureaus does not remove a debt. In other words, she's saying whenever we have asked a credit bureau to remove a debt, they always do that. So let's see if we can figure out what's happening here. And so if the debt collector had checked the plaintiff's credit report to confirm whether Equifax had complied with the deletion request, it would have risked further harming the credit because how credit checks are counted. That's not actually true, okay? So there are very easy ways for a debt collector to check your credit report without it being a hard credit pull, okay? But look, the debt collector made this argument, the plaintiff accepted it, and so the judge is accepting this also, that, okay, the debt collector made the request to Equifax to delete, and they could not go check the credit report to see, okay? So let's go on. No dispute that, remember, this is the Tennessee Orthopedic Alliance, I think it is. That's the medical provider. That removal of the plaintiff's debts from the credit bureaus would have been more beneficial to the consumer than simply having them denoted as disputed, okay? And so it's a common sense thing, right? It's better to have no collection account than to have a collection account that says disputed by consumer. All right, so what does a consumer do to fight these arguments that the debt collector says, hey, we notified Equifax on December 3rd to remove the reports? And here we come back to Credit Karma. Consumer points to Credit Karma summary that she accessed on February 21st. So remember, the argument is this December 3, 2019, the debt collector says, we told Equifax, get this off the report. Well, then we come back to, and I like the way the judge reminds us here, Credit Karma is a summary, okay? And it's not directly from Equifax. And so it says, on that date, nearly 3 months after the notice was sent to the collector that the debts were disputed, the Credit Karma summary of her Equifax report continued to show those debts as past due and did not show they were disputed. Hey, that's great. We have to have that in order to bring a claim under Section 1692E8. But we have to know the timing. In other words, when did the dispute happen? When did the update happen? So it says, as of February 21, 2020, Credit Karma's website reflected the date last reported for each of these debts as December 18, 2019, 3 weeks after CBC claims it notified Equifax to remove the debts. All right, so we're just skipping some of the stuff. Again, point this out because it's really important. The report filed by plaintiff, the consumer, was not actually an Equifax report, but Credit Karma's summary of Equifax credit information. In other words, well, the judge doesn't use the word hearsay. We're starting to get into, it's sort of like, you've got a friend and they tell you something directly versus a friend says, well, let me tell you what this other friend of ours said about you. Well, now is it accurate, what's being reported or not? Well, we don't know because we're not getting it directly from the source. All right, so here's a standard of review, which just means how does the judge evaluate this motion for summary judgment? And the judge says it's appropriate where there's no genuine issue as to any material fact and the movement, that would be the debt collector, is entitled to judgment as a matter of law. So we're going to really focus on this factual dispute. So because it says material fact, then the court rightly says the mere existence of some alleged factual dispute is not enough. It's got to be a genuine issue of material fact. So a factual dispute that's irrelevant or unnecessary is of no value. Okay? But we're not going to grant summary judgment if the dispute is about a material fact and it's a genuine dispute. So what does material mean? If the dispute over it might affect the outcome. So here's sort of the classic example. I sue you for a car wreck. Okay? We crash in the middle of the intersection. I say I had the green light. You say you had the green light. Well, one of us is right. One of us is wrong. That is a material fact. Now, if you admit that you were going, 40 miles an hour and it's a 45-minute or 45 mile per hour speed limit, and I say, well, really, I estimate you were going 41 miles per hour. Well, that might be a dispute. It's not really particularly important or material unless that would be an unusual case. Okay, so let's continue here. Let me scroll down to the discussion. So here's really the core of the argument. Debt collector says we did not communicate with the bureaus about the debts at any time after December 3. And that's when they told the bureaus delete the accounts. And then it cannot be liable for Equifax failure to comply with the directive or for failing to verify that Equifax had done so. Now, the court's going to point out that's not really your best argument, okay? The collector wins this, but for a different reason. And so here's what the plaintiff says. Let me just highlight this part here. says, hey, these debts were still listed, not marked as disputed through February 21, and that on my February 21 Credit Karma summary, it's got this last reported date of December 18. So that would be after I sent the dispute in directly to the collector. So it seems like the plaintiff has a good argument here. So plaintiff contends there's at least a material factual dispute as to whether the collector communicated with Equifax on December 18 about the debts without informing Equifax the debts were disputed. And the consumer seems to assume that the debt collector had an affirmative obligation to notify that the debts were disputed. Remember, that's the second major lesson I want you to learn from this case. That the truth of the matter is, and look, I don't agree with this, but this is well established by the court, so we have to deal with it, is that there is no obligation for a debt collector to update a report and show it as disputed. But if they update a report, they must show it as disputed if prior to that update you told them, or even if somebody else told them that you disputed it. All right, so let's look here at Section 1692E. The E8 section says it's a violation of the FDCPA to communicate or threaten to communicate to any person, that would include Equifax, credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. And so that's the whole claim right there. Here's the problem. As the Eighth Circuit has explained, Section 1692E8 does not impose on debt collectors an affirmative duty to report that a consumer disputes a debt. And I remember when this case came out in 2008, this Wilhelm versus Credico, and reading it and not being excited about this case because I think the court missed it. But it's been around for so long now that it seems as if all the judges accept this. So here's the argument. The provision applies to the communication of credit information. Thus, if a debt collector elects or chooses to communicate credit information about a consumer, it must not omit to convey that the consumer's disputed a particular debt. So let me restate that. If the debt collector chooses to communicate to a credit bureau and it knows that you dispute a debt, it has to tell the credit bureau that you dispute the debt. And then here's the FTC staff commentary. If a debt collector knows a debt is disputed by the consumer and reports it to a credit bureau, it must report as disputed. But if a debt collector learns of a dispute after reporting the debt, the dispute need not also be reported. In other words, what the FTC is saying is, let's imagine I'm a debt collector and I report on you on January 1st that you owe $150. And then on January 15, you tell me the debt's disputed. Well, I don't have to go back and tell the bureaus that you dispute it unless I end up updating the report. Now, as a practical matter, debt collectors are to update at least once a month. If they're not updating, in other words, if they are just parking the account without updating it, then that's a valid basis to dispute through the credit bureaus and say, hey, you've got this furnisher. We call them a furnisher because they provide or they furnish the information to the credit bureau. You've got this furnisher that's not following your own internal rules that require that accounts be updated unless they're paid or closed out. They must be updated at least once a month. So that ought to tell you, credit bureaus, this company is not reliable and you need to investigate this and delete it. Okay. So there's kind of two approaches there, but if the collector is updating, they must mark your account as disputed. And notice what the court says here. Although the parties have devoted a substantial amount of ink to arguments about their communication, that all consumer debts must be withdrawn from the credit bureau, and characterize this as an affirmative defense, the judge is saying, you guys actually kind of missed this. The law is clear that the debt collector did not actually have an affirmative obligation to report that dispute unless it communicated with the credit bureaus about the plaintiff's credit information after learning of the dispute. So you see the pattern there? I dispute. That could be verbally. It could be in a letter. It could be an answer to a lawsuit that a debt collector like Midland Funding, Midland Credit, Portfolio Recovery, LVNV Funding, they sue me and I answer and deny the allegations. Well, that's a dispute. It could even be somebody else telling the collector that I dispute. If the collector knows, I don't care what the source is, they know or should know that you dispute the debt and they update after that, then they have to mark it as disputed or they violate Section 1692E8. And so drop down to this part. Even if genuine dispute existed, it would not be material because CBC did not have an affirmative duty to notify the credit bureaus that disputed. It only occurred such an obligation if it communicated with credit bureaus about the information after having learned she disputed the debt. So you see the court is really emphasizing this point here. And so here's when a court says dispositive question, they just mean the thing that will ultimately decide this question or this case. The dispositive question is whether, as the plaintiff argues, there is a genuine dispute as to whether the debt collector communicated with Equifax on December 18 about the debts without providing notice that plaintiff disputed the debts in violation of 1692E8. Court finds there is no genuine factual dispute. Go back to our first point. The Credit Karma report upon which plaintiff relies was not actually created by Equifax. So it doesn't count, okay? And I know so many people are very sort of tied or committed to Credit Karma. And again, it's a tool, but it's not the real thing. It's helpful, but it's not helpful when we're in a lawsuit. It's helpful to alert us, to give us a quick summary, but then we have to go pull our real reports. And I mean, I spend so much time talking to credit repair organizations, and they'll send me files and they go, well, here's the smart credit. Here's the identity IQ. Here's the fill in the blank credit monitoring. And I go, okay, I see, why you disputed this, but I need to see the real reports. They go, John, this is smart credit. It's great. I'm like, well, I don't know if it's great. It's useful, but it's not useful in a lawsuit because it's not the real thing. So we have to get that through our heads. If you want to bring a lawsuit, you have to look at your real reports. Now, you might use a Credit Karma, a Smart Credit, Identity IQ, fill in the blank, whatever the next credit monitoring is. You might use that to prepare your disputes. I'm actually not a fan of that because you don't get accurate data and you don't get nearly all the data you get with your real reports. But let's just say you prepare the disputes. Well, then you should get the results of investigation back from the bureaus. Okay, that's great. And then go pull the real reports. Do it for free once every 7 days, annualcreditreport.com. It's about as easy as it can possibly be made. And I just find so many people are sort of set in their ways and they're like, I don't like to do that. I like to use my credit monitoring. And look, I get it. Credit repair places, they make money off the credit monitoring. So, there's nothing wrong with it, but they make an affiliate. You might be charged $30 a month for it and they might make 15 of those dollars a month. Well, if they have 100 clients, 1,000 clients, there's some reasons and it's very easy. Okay. And I've used Smart Credit before. It has its advantages, but not when we're talking about litigation. When we're talking about litigation, you have to pull your real reports. All right, I'll step down off my soapbox. Okay, so the Credit Karma report does not actually prove anything. So here's this last reported December 18, but nothing on the report indicates who did this reporting or what data the report was based on. December 18 could be the date Equifax updated its report, erroneously failing to heed the December 3 directive to remove, or the date Credit Karma last updated its records. It looks like to me there was no discovery, in other words, no depositions taken of somebody from Credit Karma, somebody from Equifax. And so the only evidence, we kind of skipped over it, but CBC, the debt collector, basically said, we don't know what that means about last reported. Maybe they waited a month from when we reported and then they updated. And the problem is the judge had no evidence that would be in favor of the plaintiff. So look at this last part here. the form does not indicate that the debt collector communicated with Equifax on that date. It's simply silent on that question. It certainly gives rise to the possibility the debt collector communicated with Equifax, but a possibility is not the same as probability. Now, we can kind of, get into an argument about, is that exactly the right standard? But I understand what the judge is saying, that you've got to have something that tells me that a reasonable juror could find that the debt collector did, in fact, update the report. And what I don't know is why the consumer was not able to pull an annual credit report. Or, let me give you a little bit more detail. If you want your Equifax report, you go to myequifax.com. And right now you can pull about 6 reports a year. It's not in a easy to print format, but it's still, you can get all the detail. You just have to do kind of print screens or screen record. Go to Experian.com, get your Experian report. I'm not aware of how to go directly to TransUnion and get your report for free other than through Annual Credit Report, which does lead you to TransUnion.com. But, even if you can't get it for free, if we're talking about suing, go buy your report. It's like $15. If we're filing a suit that's going to make you thousands of dollars in damages, it's worth spending a little bit of money. And so anyway, that's my advice. I know a lot of lawyers disagree, but that's something we've been preaching for many, many years. It's kind of like, I can't tell you for how many years I've been beating the drum of don't file these cases in federal court. You file them in state court. And I may or may not cover it, but there's a recent U.S. Supreme Court case that threw out in a class action verdict against TransUnion, I think like 7,000 or 6,500 class members saying, well, you don't have what's called standing. And the solution to that is you file in state court. So these are just some strategies we've learned over 20 years of doing this. You get your real reports and you file in state court. All right, so let's see here. In sum, the court finds defendant did not have an affirmative duty to communicate with credit bureaus, and there's insufficient evidence in the record permit a reasonable jury to conclude the debt collector communicated with Equifax on or around December 18 or any time after receiving the notice that the debts were disputed. And so summary judgment. And you can see this was June 24th, so just a couple of days ago. So hope that that's helpful to you. And if you have any questions, comments, thoughts, just put those below, or you can reach out to me directly at alabamaconsumer.com. Okay, guys, thanks for watching. Talk to you soon. Bye-bye.